Welcome, everyone. Thank you so much for joining on behalf of the Birnbaum Women's Leadership Network at NYU Law. We are so thrilled to welcome you to our tonight's event, The Fight for Gender Justice, Part 2, Equal Rights in the 21st Century. Along with the Ms. Foundation for Women, the ERA Project at Columbia Law's Center for Gender and Sexuality Law, and NYU Law's Law Women and Outlaw, we're so thrilled to welcome you to tonight's panel. Before we begin, a few logistics. Live captioning is available for this event, so to access the captioning, please click on the caption button at the bottom of your screen. For those seeking New York State CLE credit, please record all CLE attendance verification codes announced during the program. Following the program, attendees will receive a link to an attorney affirmation and evaluation form. To earn CLE credit, you must complete the form and enter all CLE codes announced during the program. So now, without further ado, I am so pleased to introduce Teresa Younger, the President and CEO of the Ms. Foundation for Women, who will deliver tonight's welcome remarks. Teresa is an activist, advocate, renowned public speaker, organizational strategist, and proven leader in the philanthropic and policy sectors. We're so honored to be collaborating with her and the Ms. Foundation on this important series. So now I will turn it over to her for the welcome remarks. Thank you, Teresa.
Thank you, Abby. Thank you, everybody, for joining us this evening. I'm really thrilled, and on behalf of the Ms. Foundation for Women, we are thrilled to be in this partnership. Let me wish everybody a happy International Women's Day today. What better day to have a conversation about the ERA than on this very day where the rest of the globe recognizes the importance of the lives of women and what we need to be doing. These are very incredibly challenging times, and we know that to be true on so many levels. And in some ways, there's no greater time for us to be having this conversation about the ERA than right now. You all could be anywhere tonight, and yet you have chosen to join us. Join this very esteemed and established group of legal scholars in this conversation tonight. As we talk about the ERA, we must remember that the US Constitution does not explicitly guarantee the rights it protects to those citizens without regard to sex, i.e., women are not mentioned in the Constitution. And so without an ERA, or the 28th Amendment as it would be, we are left unprotected on so many levels for so many, many reasons. Tonight, you will hear some of the arguments around the history and where we're going with the ERA. At the Ms. Foundation for Women, we are often positioning ourselves to be in partnership with those closest to the problems in their communities in hopes to lift up those issues. And when we reflect on what a constitutional amendment would look like, what it means to have an ERA written into law, we understand that those closest to the ground would be greatest impacted because they would have the real, true lived experiences. We don't have to go too far to understand where and how the ERA might be playing into today's conversations, especially since Roe v. Wade is sitting in front of the Supreme Court. And we have issues coming out of Texas, like the latest laws that are going on around criminalizing family members who are trying to help support their trans children and siblings. We are also seeing laws passed in Florida, which are limiting what can be discussed in a classroom. Once again, alienating what we are talking about in terms of what it means to have equal rights protected in the Constitution. We are really excited about tonight's conversation. We're excited because we know if we can get things written down clearly and explicitly, then we don't have to guess what our founding quote unquote fathers were intending with the Constitution. They were not writing it for me, not me as a Black woman, an Indigenous woman, or a woman at all. And so we need to make sure that as we move forward, the Constitution is protecting all of our rights and all we want to do. It is not limited to conversations around abortion and access to abortion. It is not limited to bodily autonomy. How the ERA could be instituted and implemented could be groundbreaking for what we can't even see into the future. Our founding fathers had no idea the strength and power we would be faced with today. And tonight's conversation will be led by an amazing leader in the field. Kate Shaw is a law professor at Cardozo Law School and is the co-director of the Florsheim Center for Constitutional Democracy. She has worked in the White House counsel's office as the special assistant to the president and the associate counsel to the president. She clerked for Justice John Paul Stevens in the US Supreme Court and Judge Richard A. Posner in the US Court of Appeals for the Seventh Circuit. Her teachings and her research and her interests include constitutional law, legislation, administrative law, the Supreme Court, election law, and gender and sexual orientation and the law. I will tell you, I've followed Kate for many, many years. I spent a short stint of my time as a non-attorney at the ACLU, and I know her work and what she lays out for us. I'm thrilled and honored and so very appreciative for her work and the work of all of our legal scholars tonight as they talk to us even further about this conversation about the ERA. So, Kate, the floor is yours.
All right, Teresa, thank you so much for that generous introduction. It is such a privilege to be here with this group on International Women's Day for such an important conversation. Because time is short, I'm going to forego lengthy introductions and just tell you who you're going to be hearing from tonight together with their institutional affiliations. So the panel tonight will be Alexander Chen, who's the founding director of the LGBTQ+ Advocacy Clinic and also a lecturer on law at Harvard Law School. We'll also have Ting-Ting Cheng, who's the director of the indispensable ERA project at Columbia Law School's Center for Gender and Sexuality Law. That center needs to be on your radar if these issues are of interest to you. We'll also be joined by Serena Mayeri, a professor of law and also of history at the University of Pennsylvania Carey Law School. And finally, we'll be joined by Darren Rosenblum, who's a professor of law at McGill University. So welcome to all of you, really excited to dive right into these issues. So maybe Serena, you're a historian. I'm going to ask you to get us started. Can you just start by framing the conversation with a little bit of history? What is the ERA? How does it initially come about? And how does the effort that has led us to where we are today sort of get underway?
Thank you so much. I want to add my thanks. It's really an honor to be with all of you and to be part of this distinguished panel. So I guess I'll start by saying that the ERA itself was first introduced in a slightly different form in 1923, not long after the 19th Amendment became part of the federal Constitution. It was proposed by the National Women's Party, drafted by Alice Paul, who's I guess the better known drafter, and also by Crystal Eastman, an NYU grad who's not always given credit for this particular accomplishment. And it was aimed at securing equal rights for women, kind of across the board in areas including marriage and divorce law, employment, civil rights such as the right to contract, the right to own property in one's own name, to access an equal education. And of course, this fight for legal sex equality began long before 1923 with, for example, the women of the 1848 Convention in Seneca Falls who called for equality, and with Black and white abolitionists, feminists connecting the anti-slavery cause to the rights of women in the years following. I guess a couple of things to say about the interim in between the 1920s when the ERA was first introduced and when it is passed by Congress in the early 1970s. This is a period in which advocates for women's equal status were really divided over whether the ERA was a good idea. In particular, many women who were active in the labor movement were concerned that formal legal equality would mean that labor protections that were specific to women, such as minimum wage and maximum hours laws, wouldn't be allowed. But by 1970, for a variety of reasons, which I can say more about later, most feminists had agreed to pursue an ERA alongside legislation and alongside litigation under the 14th Amendment's Equal Protection Clause. And by this point, there's a new crop of women in Congress, women like Patsy Takemoto Mink and Shirley Chisholm, along with Martha Griffiths, who get behind the ERA and push it through Congress with the help of male allies from both parties. And then it goes to the states for ratification. And what ensues is a somewhat unexpectedly controversial debate. Phyllis Schlafly, now of Netflix fame, launches a social movement that not only ends up defeating the ERA in the states, but also really accomplishes kind of a wholesale partisan realignment, or helps to accomplish that realignment. And the Stop ERA movement that Schlafly led, contends that the ERA is a really radical change that threatens the integrity of the family, would force homemakers into the workforce, would abolish alimony, would draft women into combat, make abortion available on demand, mandate same-sex marriage, and require unisex bathrooms. And to make a long story short, the ERA's original 1977 deadline gets extended until 1982, but the amendment ends up expiring when it's 3 states short of ratification. And the ERA is actually reintroduced shortly after it fails in 1982, and hearings are held, but then there's a period of relative dormancy. And I guess I'll stop there and maybe turn it over to Ting Ting to talk about the more recent revitalization of the amendment.
That's perfect. And just let me jump in to fill in just for folks who aren't familiar with the constitutional amendment process set forth in Article 5 of the Constitution. To get the Constitution amended, you need a 2/3 vote in each House of Congress, and then 3/4 of the states have to ratify the amendment. So exactly as Serena was just describing, congressional passage is achieved, and it looks as though the ERA is on a fast track to be ratified by the requisite 3/4 of or 38 states. And then this partisan alignment, in part, I think in no small part, attributable to Phyllis Schlafly's Stop ERA, which is sort of an acronym for Stop Taking Our Privileges, what her organization was called. And other forces, I think, too, sort of grind to a halt what had been this really initially very quick ratification process. So things stall out before the deadline, the second deadline. So the initial resolution, right, attached to the first, or the 72 Equal Rights Amendment, basically gives, I think, a 7-year period for ratification in the states. That, when it looks like there's a little more time is going to be needed, Congress then extends that deadline to 1982, but things stall out at 35 states in 1982. So yeah, Ting Ting, do you want to basically, I'm not sure exactly where you want to start, but obviously at a certain point, there's this revitalization that sort of begins to get underway, and sort of, can you talk through that process, particularly in the last couple of years?
Sure. First, I want to echo what Serena said, which is it's a total honor to be on this panel with you guys talking about the ERA. So thank you for having me. Well, I'll start out with sort of the situation today, which is depending on who you ask about the ERA, some people think that it's the 28th Amendment. Some people think that, it's in legal purgatory. And some people think that its dead letter, died in the 70s, cannot be revived, a zombie, so, and all of the legal questions around the ERA and the ratification are novel. I would say that these questions have not been answered by the Supreme Court. And you can look to kind of historical precedent for some instruction, but a lot of these questions also are novel in that sense too. And so, and we're so close, as Serena says, all Article 5 requirements have been satisfied, which is an incredibly high bar on Congress and on the states. So, where we are today is quite interesting, because many people thought that the ERA was done when the deadline extension expired in 1982. And I think what sort of planted the seeds in the advocates' minds that maybe it can have a viable revival, was actually the ratification of the 27th Amendment, which happened in 1992, over 200 years after it was first proposed by the first Congress, by James Madison, at the beginning of the founding of this country. And so again, Article 5 requirements under the Constitution were satisfied in that case. Congress passed it with a 2/3 majority. And then in 1992, 38 states had ratified it. So it started to plant the seed with ERA advocates and sort of the feminist movement that, wait a minute, so maybe this time limit that expired is invalid. Maybe we can just ignore it because it doesn't really have any kind of legal effect on the life of the ERA. That, along with I would say the kind of the revitalization or this current version of the kind of gender justice movement right now, beginning with the election of Trump and just different movements that were swirling with the women's movement, Time's Up, Me Too, and everything. I think it really emboldened people to try to think differently about kind of like the picture of modern equality, and the ERA is a very good vehicle for that. And I have to say that, it's I'm very proud of the fact that, it's Black women in state legislatures led this ERA revival in the 21st century. So including Pat Spearman in Nevada, Juliana Stratton in Illinois, and Jennifer McClellan in Virginia. So, and as a result, Nevada, Illinois, Virginia became the last 3 needed states to ratify the ERA in 2017, 2018, and 2020. The third article of the ERA says that, this provision will become operative 2 years from the date of the final ratification. Virginia became the 38th state to ratify in January 27th of 2020. And so January 27th this year, many people saw that as the date when the ERA is now the law of the land. There are some very serious legal questions to do with what to do with these, with the time limit that expired in 1979 and 1982. How do you treat the validity of those last 3 state ratifications? And also at the same time, what do you do with the handful of states who have voted to rescind their previous ratifications of the ERA? There's ongoing litigation precisely to do with this issue. Part of it is to try to get this administrator to rubber stamp the ERA. Everybody agrees that what he does or doesn't do doesn't give the ERA legal effect. But I think the underlying issue is also to get the courts to recognize the validity of the ERA so that people can go to court and start to use it as a tool in litigation. The question of the deadline was hotly debated in the Department of Justice and the executive branch, which we all know historically does not play a part in the Constitution amendment process, especially under Article 5 textually. So, under the Trump administration, the Department of Justice issued this very long and, we think constitutionally problematic memo that declared the ERA dead, and that congressional deadline binding, and also that Congress cannot do anything about that later on, which is inappropriate for them to opine about, a separate branch of government who have explicit textual authority under the Constitution to resolve constitutional amendment questions, right? So then recently the Department of Justice have issued a kind of a change position that's neutralized that Trump era memo and basically said, these are very complicated questions. We are not the ones to step up to resolve them. Actually, we think it's really appropriate for Congress and the courts to resolve it. And so the ball's kind of in Congress's court right now. And the question also is sort of like, do we have the political will? Can Congress, especially the Senate, step up and vote to lift the time limit? So, these are novel issues, but issues that are being debated hotly in all 3 branches of government. And for the people who say, well, the ERA is kind of dead, is that your grandmother's revolution? It's not. It's really has never been closer to being in the Constitution, has satisfied all constitutional requirements.
So thank you, Ting Ting. That's such a great overview. And maybe I'll just keep you for 1 beat longer, because I think that the context is really helpful. And so there's a bunch of sort of swirling related questions here. So one, as Ting Ting said, for some people, we have a 28th Amendment, like the ratification has occurred. All the Constitution requires is Congress and the states. And so it's our law. We just have to recognize it, and courts need to enforce it. And yet the political actors in our government I don't know, or I'm pretty sure are not yet convinced of that fact. So Ting Ting mentioned an administrator. So the archivist of the United States actually has the kind of, paperwork, ministerial duty of actually formalizing an amendment to the Constitution. But I think exactly as Ting Ting said, everyone agrees that this executive branch official doesn't have the final say on whether something is or is not part of the Constitution, and yet has not yet done the certification that would be required at least to formalize the inclusion of the ERA in the Constitution, even if, again, the final legal authority certainly does not reside with the archivist of the United States. But where it does reside, I think, is a difficult question. So the Office of Legal Counsel in the Trump administration basically took the position that because the deadlines, exactly as Ting Ting said, because the deadline had expired, the ERA was a dead letter and the process would need to start afresh in order to result in an effective amendment to the Constitution. under the Biden administration, I'm not sure, Ting Ting, if you can disagree with this characterization and feel free to correct me. I would say there wasn't a full repudiation of what the Trump administration OLC had advised, but there was basically a revision or an amendment, that essentially said, it's not really our call, right? The Congress is essentially in the driver's seat to decide if the Constitution has been validly amended. And so if Congress wants to, either recognize these ratifications or formally extend the deadline for ratification, that's Congress's prerogative. It's not the executive branches, and it's not really the courts either. So there is this kind of institutional authority, institutional role question. So maybe one more beat on that, Ting Ting. So where do things stand in terms of what Congress has done right now? You mentioned the Senate needs to move. So the House, has taken this up, and sort of where do things stand from the legislative perspective right now on ERA?
So the viewpoint is that the actions of one Congress cannot bind the actions of future Congresses, right? So it's the most representative branch of government. It's supposed to represent the will of the people. So something that a Congress does in the 70s can be binding on all future Congresses. And obviously the Supreme Court hasn't issued an opinion on this exact issue, but there are many kind of like historical prudential arguments for this viewpoint. And so the House actually passed a joint resolution twice to lift the time limit. And now a similar joint resolution is before the Senate. And, it's been there for over 2 years. And obviously it's not gaining a lot of traction because of the filibuster. And so I think right now there are 2 Republican senators who are on record for supporting this joint resolution to lift the time limit, Senator Murkowski and Collins. But we need 8 more, and I think that maybe the chances are not the greatest. I'm not holding my breath. So that speaks to the political will. Now, that I think presents a really huge kind of like democracy problem to me, because if you look at the text of Article 5, there are 2 extremely high bars. You need a supermajority in both houses of Congress. Then you need a supermajority in the state legislatures. And now it seems that the ERA is stalled by kind of like a third sort of like supermajority requirement that seems quite anti-democratic to me, is that you need a supermajority to overcome this filibuster in the Senate. So that's kind of what the political situation is. On the 27th of this year, to kind of commemorate the moment when the ERA either became the 20th Amendment or ought to be considered the 20th Amendment in the Constitution, Representatives Jackie Speier and Carolyn Maloney, I think, proposed a new joint resolution, just kind of recognizing that the ERA has been validly ratified. I think that that's, symbolically very powerful, but at the same time, it doesn't address the time limit issues head on. And again, going back to the 27th Amendment, no one is litigating any kind of issue with whether the 27th Amendment has been validly ratified. But I think that there are people who are going to make their careers litigating whether the ERA time limit is valid or not, and so this is an issue that needs to be kind of confronted head on.
I think that's right in the courts and in Congress, but the political will piece of this, because I think it's right. The Supreme Court has sent very strong signals that the question of when ratification is effective and when it is not of the Constitution is really fundamentally for Congress to decide. And so pressure on Congress, I think, is the most important sort of next front in the battle for ERA, effective ERA inclusion in the Constitution. So maybe that's a good pivot to the goals of actually including the ERA in the Constitution today. Serena alluded to some of the goals that the kind of original, my former Cardozo colleague, Julie Suk, has this wonderful book, The Founding Mothers of the ERA. And so what, so the goals of proponents have really shifted over time. So maybe I do want to bring Serena some historical perspective to bear, but maybe if Alexander or Darren has anything, any thoughts on sort of the goals of ERA, proponents today, I'd love to bring you into the conversation at this point as well.
Well, thank you so much. I'm really excited to be part of this incredible group of people to honor International Women's Day. And I think really there's no more important conversation to have here in the United States than this one, given the centrality of the ERA. I think the thing that I would add, and I'm curious to hear what Alexander would say, is that as relevant as the ERA was in the 1970s when the big push occurred. I think it's equally relevant today. Gender inequality is still rampant throughout society. In the corporate sector where I work, women are 8% of CEOs. There are more CEOs named John than all women CEOs combined. And essentially, we see a circumstance in which the private sector is functioning in a way that is really largely exclusionary toward women. I also think that the ERA is especially important because we as a society, and not just in the United States, but throughout the world, are grappling with the recognition that there are more than two sexes, that there are transgender people and non-binary people such as myself who deserve inclusion. And I think the language of the ERA is really pointed and simple in a way that would advance everybody's rights in important ways.
Thank you. That's so helpful. Alexander, do you want to add anything in terms of sort of the general perspective or general goals of the ERA today? And then I think we'll drill down on a bunch more specifics.
Yeah, I mean, I think that, we're probably going to get a little bit more into this. And wait, I should just back up and say, also very excited to be here, really excited to also listen and learn from this really distinguished and illustrious group of thinkers on this issue, and really happy to be here to share a little bit also about, the ways in which this can impact LGBTQ plus advocacy, which is really, my lane. And so, I think building off of what Darren said, of course, without the passage of the Equal Rights Amendment, the reality is that litigators and advocates have had to try to backfill the lack of that explicit grant of protection by trying to litigate up the fact that we should be protecting people from discrimination on the basis of sex, both in the context of constitutional litigation with the establishment of the intermediate scrutiny branch, but also with respect to statutory protections with various different federal civil rights laws to protect against sex discrimination in contexts like employment, education, healthcare, and housing at the federal level and also at the state level. But all of those protections are really a patchwork compared to the overall overgirding protection that we've been provided by the explicit constitutional amendment. And the reality is that intermediate scrutiny, which is the level that you analyze sex discrimination on, is not as powerful as strict scrutiny. And that has resulted in, for example, it's one of the reasons why we have case law in which there is a really big distinction between how we're treating different kinds of racial discrimination and different kinds of discrimination on the basis of sex. And I personally have a belief that it is something which impacts, for example, the fact that although, sex discrimination is recognized when it comes to a woman isn't being treated the same as a man, when it comes to a situation where they just want equivalent treatment, there has been a lot less protection for women when they encounter things that are distinctive to the experience of women, like pregnancy, right? And there has been a way in which that has been given a lower level of scrutiny and a lower level of deference by the courts. And I think that this kind of amendment would really reset the game and say, no, you can't have that kind of precedent, that we can't have constitutional or statutory interpretation that doesn't see women as equal to men unless what they're asking for is equivalent to what men have. And so, of course, that is a little bit of a how would that go if it got passed? And then how would the judiciary interpret it and the judiciary that we have now? So I'm not going to go out on a limb and say it would transform the world of our jurisprudence, but I think it would really put advocates in a really stronger footing in making all these different kinds of arguments. And we could talk a little bit about how that is also going to have a really beneficial impact on gender and sexual minorities like LGBTQ plus people, gender nonconforming people, non-binary people, and intersex people. I think that that's something that Kate's going to turn into a little bit later on. But I think that it's not just about that, right? It's also about the rights that this would give to women as a broader category.
Great, so helpful. And just a little additional context for folks who aren't as steeped in the history, right? The court has basically announced as a matter of constitutional 14th Amendment equal protection jurisprudence that, and this is what Alex was alluding to, that sex discrimination gets scrutinized at a lower level than racial discrimination, right? That it's subject to intermediate scrutiny rather than strict scrutiny. And the history of the development of that standard is quite intertwined with the ERA. So the court came within one vote of actually basically accepting that sex discrimination gets scrutinized using strict scrutiny, but doesn't quite cross the fifth vote is never quite available. And that is in part because the Supreme Court at the time believes that the ERA is on this fast track to ratification. And so once that's in the Constitution, that's going to be an independent basis for protection against sex discrimination. And of course, that never, until maybe now comes to pass. And so you have this asymmetry. So that sort of corrective is, I think, one, clear objective of the ERA. But today's ERA, exactly as Alexander was alluding to, and Darren as well, could potentially sweep much more broadly. So maybe Serena,
Can I just add?
Please go ahead, Ting Ting. Yeah.
Sorry, I want to say I absolutely agree with that assessment. And I think like it's imperative that we get that kind of like the highest, the most exacting level of judicial scrutiny when it comes to these forms of discrimination. But, the thing that I'll add is a layer onto that kind of analysis is that the 14th Amendment has obvious limitations, and I think has been used, especially in the recent decades, as a tool to undermine equality. We've been doing a lot of analysis of the ways in which courts have been, especially during COVID times, right? Like using strict scrutiny to strike down laws that would remediate and to offer, just fast track sort of grants to minority-owned restaurants or women-owned restaurants based on historic inequality. And the courts in that instance, and this is one case, the Sixth Circuit in Vitolo, they said that they had to, with strict scrutiny, they had to use like a scalpel. They had to be so exacting about the different rights that can flow from that. And what ends up happening is that it actually ends up taking away much needed affirmative action from people who have historically been marginalized. And how do you correct inequality by treating everyone with neutrality? So I think that that's something that the ERA is, calls into question and would transform, right, the current understanding of strict scrutiny under the 14th Amendment.
Right, that's great. So we're maybe in its initial sort of conception and inception, protection of historically marginalized and subordinated groups, seems to be the primary objective of the Equal Protection Clause. You're saying, even if the Equal Protection Clause were read, to protect against sex discrimination in the same way it protects against racial discrimination, the current Supreme Court takes this sort of context blind approach to discrimination and suggests that discrimination on the basis of race, or if it adopted strict scrutiny on the basis of sex, whether it is designed to entrench or remediate, inequality and hierarchy, gets treated in an identical fashion. And that's a fundamental flaw in the approach of the Supreme Court. So maybe, it's not, there's an additional reason that the ERA could provide a completely different understanding of the Constitution's, potential for meaningful anti-discrimination protections.
And we need that understanding.
Yeah. I think that's a great point. So maybe Serena, could I bring you in a little bit on, before we get a little bit more into the weeds on how, and I want to not be too sort of focused on how the Constitution, if the ERA were part of it, might, protect people in judicial proceedings, but also think about the ways in which the ERA might enable affirmative legislation, which is also something that Ting Ting sort of alluded to in that observation. But before we shift to that, Serena, can you just talk a little bit about how sort of the ERA movement has evolved over the years and sort of how it intersected with and overlapped with the civil rights movement and sort of how it has evolved alongside kind of today's more intersectional feminism? I feel like a little bit more history would be really useful here.
Absolutely. So I think the ERA's goals have changed over the years in some of the ways that we've been suggesting, both as the law has changed, in part as a result of ERA advocacy and advocacy under the Equal Protection Clause of the 14th Amendment and legislation, and also more conservative judicial decisions that have left open a lot of unfinished business that, as we've been talking about, the ERA might help to address. I guess one way of thinking about this is that when the ERA was reintroduced in 1983, after it had expired, feminists and proponents of the ERA tried to sort of reinvigorate a new legislative history for the ERA and fill in some of those gaps. And I think we have a broader and more expansive agenda today, but some of those gaps that proponents were trying to fill in 1983 are still with us, and I think, as we've been discussing, still part of this. So for example, by the end of the 1970s, the Supreme Court had interpreted the Equal Protection Clause as requiring that discriminatory intent be shown, that a law be shown to have been enacted intentionally to discriminate in order for it to be invalid under the Equal Protection Clause. And ERA proponents wanted to expand the vision of discrimination to include laws that had a disparate impact on women and other disadvantaged groups. So that's part of what they hoped the ERA would do. Same with affirmative action. Court had already started to interpret strict scrutiny in this very kind of colorblind way. And what ERA proponents hoped, was that an ERA would make affirmative action perhaps even mandatory in certain contexts, but would invigorate that type of affirmative protection for equality. Some proponents also wanted to undo some of the Equal Protection Clause jurisprudence that hadn't been particularly effective thus far in providing for abortion funding, for example, state funding of abortion. So all of those were on the agenda. So that's sort of how the law had changed and not changed, and how there was a lot of unfinished business still to do, even sort of at that point in time. With respect to the changes in social movements, I really want to underscore what Ting Ting said earlier, that this new revitalization of the ERA movement has been led by women of color in state legislatures and elsewhere. And I think it's important to note that while the ERA movement has sometimes been seen as a kind of white middle class or professional movement, women of color have been central to it from the beginning, and certainly since the 1970s, when it was women of color like Representatives Mink and Chisholm, Polly Murray as among the most prominent supporters in the 1970s, who were taking an intersectional approach to the ERA and also to litigation and legislation and other means of achieving equality. And I think it's important to note, really crucial to note, that so much of the unfinished business of sex equality today is very intersectional. It really has to do with inequalities and injustices that are experienced most by women of color, by LGBTQ plus people, by immigrants. So if you think about income and wealth inequality, access to safe work at fair pay, access to health care, freedom from violence, reproductive injustice, attacks on trans kids, and on people who are incarcerated or undocumented. These are all deeply intersectional harms. And I think it's fair to say that women and queer people of color have really been at the forefront of struggles to address them. So to my mind, I think this is inherently and importantly an intersectional movement today. We haven't even mentioned attacks on democracy and voting rights, which are really foundational to everything else that we're talking about. And those movements, of course, have also been led by people who are really at the intersection of these inequalities and harms.
Great. So maybe in terms of then how we think, just to get, now let's get, I think, more concrete. And maybe Ting Ting, let's start with thinking about what role the ERA might play in the battle for reproductive rights and justice, which is obviously of crucial importance right now. We are probably on the precipice of the court overturning Roe and abortion being, banned outright. And Serena probably knows the number, north of 25 states by midsummer. As things appear to be proceeding right now, how might the ERA impact the battle for reproductive rights and justice?
So, it's just a really dire landscape right now. The fight for the federal constitutional ERA is ongoing, but we can at least be heartened by the fact that there are 26 sort of state level ERAs in the state constitutions that can be enforced and in a way that's more robust than before. And some of those ERAs have been used to as a tool to protect abortion access in New Mexico, in Connecticut, and in Massachusetts. And we recently submitted an amicus brief to the Supreme Court of Pennsylvania to on behalf of abortion providers who are challenging the state abortion ban on Medicaid coverage. So I think going forward, there has to be sort of a deeper thinking about using equality rights to protect abortion access. Just to go back to the history a little bit, I think that, I think it's maybe the result of like a pragmatic compromise of the women's movement in the past. It makes sense in order to get support for the ERA in Congress is to sort of like detach the ERA from abortion access or from reproductive rights. And that's been swirling around for a long time. I think the heartbreaking thing about that kind of strategy is when the movement basically conflated a political strategy and turned it into, or tried to turn it into a legal strategy, right? When sort of like people in the women's movement, started writing kind of legal briefs about how there's no relationship between the ERA and the right to abortion and things like that, when clearly it's not a very strong legal argument, because even the Supreme Court has acknowledged that there are sort of like equality rights implicated in the right to reproductive rights. And so I think that at the state level, certainly there's some kind of tools and, and also kind of on the ground advocacy that can be utilized to start to build a new protection for reproductive rights, and to also think differently about abortion, not as this like isolated kind of like political wedge issue, right? As kind of like a part of the kind of reproductive spectrum that implicates all of these other issues, from kind of maternal mortality and and the childcare economy and all of these other issues that have to do with reproductive health and abortion too. I think that kind of work has to happen at the state level.
Great. So Darren, can I bring you in now to talk a little bit about insights from your work on board diversity and basically how the ERA would play into various efforts taking place both in government and in sort of corporate quarters, for instance, on things like board diversity mandates. How does could the ERA impact all of those sorts of efforts?
Well, I think it's a central question to broader issues of equality, because of course most of our activity in the economy is generated by the corporate sector. And so the fact that there's such a vast disparity between men and women in the corporate sector leaves women out of everything that we do in our lives, right? Women are in dependent, vulnerable positions thanks to the systemic exclusions that occur. And so I do think a central remedy for this is to promote inclusion of women at the highest reaches of the corporate structure. So about 20 years ago, Norway started passing a quota for women on corporate boards. Their quota was a hard 40% quota. It spread throughout the many developed countries. So now 8 out of 10, the top 10 economies of the world have some sort of mandate for including women on boards. And within the corporate structure, the board is the central body that makes decisions as to who to name for CEO. And it also plays an important legal role. So I think that this shift is an important one in terms of fostering inclusion in the private sector. It's been well tried abroad, and now in the United States since 2018, there's a mandate in California that also requires inclusion on corporate boards. And one thing that we've seen is that the private sector is really generally pretty excited and motivated to comply with these inclusion mandates, because I think they recognize that women play a central role in our economy and should be part of leadership. The ERA, I think, would play a central role in supporting it, because as these mandates start to spread in the United States, whether it's California's mandate or private sector efforts like the NASDAQ rule, which also encourages inclusion on boards. These efforts are being challenged by opponents of equality. And I think the ERA would really bolster the defense of these efforts and also encourage people who are engaged in different ways of either mandating diversity and inclusion or even voluntary efforts for inclusion. A constitutional amendment isn't just about the law, it's also about how we think of ourselves as a society. And I think corporate America is really ready for that message.
That last point is so important, right? There is this both tangible, concrete, and also deeply symbolic component to any constitutional amendment and even any constitutional amendment effort. I mean, I hope if we have a couple of minutes to sort of talk and think about, even if there isn't consensus among the political branches that the ERA is actually the 28th Amendment, has it actually spurred meaningful change along the way? But before, we're running a little short on time, and I want to make sure to bring in Alexander. Can you talk a little bit, Alexander? And I want to actually read the first clause of the ERA, which says, equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. Obviously, over the past 50 plus years, our understanding of sex and gender as related, but distinct concepts has evolved significantly. How would the ERA as presently drafted and how it might be interpreted, how might it be used to further transgender and non-binary rights, LGBTQIA+ sort of rights more broadly? Is the language broad enough to encompass protections for sexuality and gender expression and gender identity as it's currently drafted? I'd love your thoughts on any and all of that.
Yeah, that's such a great question. And I'm going to do something which is kind of a professor thing to do, which is I'm going to take a question that's in the chat and I'm going to use it as a launching point to address this question, right? So somebody in the chat asked, can the ERA ever realistically pass if we wanted to also protect the broader agenda for the rights of transgender people, and in fact, everyone, when it has enough trouble passing when it just covers the more quote unquote traditional definition of women? So there's a couple of different ways I want to sort of break that down, right? So one is, I find it really interesting, this framing of the idea that it's a broader agenda to address the rights of transgender people than to address discrimination on the basis of sex, right? And I want to go back a little bit to the history. Now, when Serena was talking about the history, one of the things that she pointed out is that, Phyllis Schlafly and her Stop ERA movement was a really integral part to the defeat of the ratification of the ERA at a really critical point when it was like between that 35 to 37 state threshold, right? And one of the key arguments she used was this argument that this is going to be the end of bathrooms. This is going to be end of sex segregated bathrooms. And actually, the same arguments have surfaced again and again when it comes to various different civil rights movements within our history. When the Gavin Grimm case went up to the Supreme Court and then back down to the Fourth Circuit, which was the case involving the transgender high school boy who was trying to access male bathrooms in his high school, the Columbia Gender and Sexuality Clinic actually helped to author a really fantastic brief from the NAACP, which highlighted the historical links between those arguments that were being used about transgender people in bathrooms today and how they were supposed to be predators. And there was this fear of safety and this fear of protecting women, and how those same arguments were historically used when it came to saying that African-American people should not be using the same bathrooms as white people because it posed a threat to white women, right? And talking about how those kinds of fears about safety and privacy were weaponized in order to defeat the equal treatment of African Americans under the law. And really the same argument can be made about the way that those bathroom fears were weaponized in order to defeat women's equality when it came to the Equal Rights Amendment. So I think we can't really pretend that all of these different struggles don't have deep connections in our civil rights movements, that actually these rights historically do rise and fall together, and a fear of addressing some of these arguments that are based upon prejudice and bigotry and sort of scaremongering ultimately are going to redound to the negative impact of all of the communities involved. So that's the first thing that I would say. The second thing I would say is that the ERA as written doesn't say men or women, right? It says discrimination because of sex. And the interesting thing is that if it is passed in its current form, under current Supreme Court precedent, it automatically already covers people on the basis of gender orientation, gender identity and sexual orientation, because in 2020, the U.S. Supreme Court, decided a case called Bostock v. Clayton County. And the question in that case is, for the purposes of Title VII of the Civil Rights Act of 1964, when it says that you can't discriminate in employment on the basis of sex, does that include LGBT people? The cases that were consolidated involved 2 gay employees and 1 transgender employee. And the Supreme Court emphatically said, anytime you have sex discrimination, that necessarily encompasses discrimination against people on the basis of sexual orientation or gender identity, because you can't discriminate against somebody for being gay or transgender and not have it somehow have something to do with sex. What the Supreme Court said was those kinds of issues are inextricably intertwined with sex. So that's already what they said when it came to the statutory argument. And that already had a huge impact on its own, because we have bars against sex discrimination, as I mentioned earlier, in already many contexts under federal and state law, including in things like healthcare and the Affordable Care Act, the Fair Housing Act, and Title IX, which bars discrimination in education. And there's already been precedent interpreting that to also apply in the context of constitutional protections for sex discrimination under intermediate screening that already exist in contexts like schools and education, and also the transgender military bans, right? Those cases, one of which I was counsel on, were litigated in part on the basis that it was a violation of equal protection and sex discrimination under equal protection in order to just kick transgender people out of the military and say you're categorically unfit to serve. So actually, we wouldn't have to argue about whether or not it would be good or bad that transgender people are included in some kind of additional way. Like the very text of the amendment and the way it's been interpreted by our courts already includes transgender people. And part of the reason for that is that if you look at the historical development of that doctrine, of how we got to a point that the Supreme Court said that, it's because there were many, many cases in the sort of like run up to that, where the reality is it's really hard to distinguish between those kinds of discrimination, right? So if you have a lesbian at work and she is being called anti-lesbian slurs, but she's also being called mannish, and she's being accused of being too aggressive, and she's accused of having too short hair, and it's a problem that she's wearing pants at work. Like, how do you distinguish where sex discrimination ends and anti-LGBT discrimination begins, right? And I think that's because, as many gender theorists have pointed out, and I think as many people might agree in terms of their lived experience, right? There's really, it's very difficult to separate out homophobia and transphobia from sexism and from gender stereotypes, because ultimately the idea that men or women are supposed to behave a certain way, the idea that they're supposed to be in relationship with each other a certain way, they're supposed to look a certain way, that there are only men and women, even though scientifically speaking, that's not true. And there are definitely a huge spectrum of different kinds of gender that are scientifically proven, including intersex people, namely among them, as well as transgender people, that the reality is that the discrimination that all of those subgroups face is tied to the framework of gender-based oppression that we have in our society. And so it becomes analytically impossible to separate out those things when you're talking about discrimination in the first place. And that's how we got to a point in the beginning of this conversation of even saying, hey, actually, legally speaking, those things are already recognized as being connected. But I think that also that entire history showcases why it's so powerful to bring together these analyses and say, we should be analyzing these issues as being connected because the experience that we have of them is connected in the world, and our law should reflect that.
So much great stuff in there. And I do want to just underscore the point. So we've talked about this quite conservative Supreme Court has served up things, many, many doctrines that are huge obstacles to advocates of gender justice. But it is the case that Neil Gorsuch authored this really important opinion in Bostock in the statutory, not constitutional context, in which he basically makes the point you cannot disaggregate sex and sexual orientation and gender identity in exactly the way Alexander was just describing, and that logic must apply to the term sex in ERA. And so I think that is quite powerful. So it sort of runs contra a lot of the trends on the Supreme Court, but it's obviously a hugely important countercurrent. Darren, did you want to add anything to Alexander's response to that question?
Well, I just wanted to second the point that I think that it's essential to think of these things holistically, that the definition in the ERA of sex is really read broadly in its most correct fashion. And I think that really matters in terms of the work that I do on the corporate sector, that to the extent that we can increase equality, economic equality between cisgender men and women, it will make gender mean less. Part of the reason we care so much as a society, whether we have a girl or a boy and have these gender reveal parties, is because it matters so much to people. But if girls and boys had equal opportunities to be president or CEO, that distinction between men and women wouldn't matter in the same way. And that would benefit not just women, but also men, not just cisgender people, but also transgender people. Everybody would benefit from that kind of inclusion. And I think the ERA would make a big step in terms of advancing that goal.
And I just want to add a little bit more about that Pennsylvania abortion access case that I referenced to, just to connect it to everything that is so powerfully said, which is that, we really wanted to thread that needle and have a brief that's inclusive of all pregnant people, both acknowledging the fact that a lot of these laws were created to subordinate the bodies of women, but then also that the equality arguments to abortion access have to do with gender stereotyping, which harm everybody, right? The stereotypes that put women in a box as mothers or pregnant people also put other people in a box by saying that only women get pregnant. And so, the broadening these arguments for abortion access based on the ERA at a state level is meant to benefit everybody and apply to everybody in a really inclusive, intersectional way. And I believe Serena has written about this too. So she wants to add more to this. She's written powerfully about this.
Yes, Serena, I'd love to bring you in. And also, if you want to comment at all on just with, we can talk in high or specific kind of levels of detail, but if ERA was in the federal constitution, what affirmatively it would, we think, it might authorize and potentially even spur Congress to do beyond, providing judicial protection against sex discrimination that is more robust than the 14th Amendment currently provides. That's obviously a very narrow conception of what the ERA would do. More expansively, what might it, enable, or you even suggested require, the federal government to do in order to, advance gender equality and justice?
Thanks. I want to echo everything that has just been said, and just really underscore the importance of really advocating for the most expansive vision of equality that we can under the ERA, under the Equal Protection Clause, under state equal rights amendments that already exist in the form of legislation. I think all of that is really, really crucial. And as we've talked about a little bit already, there has been a temptation in the past sometimes to, for political reasons, kind of scale back the ask. And I think that is, for all kinds of reasons that we've already talked about, a real mistake, and one that we need to guard against in the event that that ERA ratification, becomes a reality. With respect to what the ERA might authorize or require in the legislative realm, I think in some ways, I think the sky is the limit. I think it would be a tool to make the same kinds of arguments that people are already making under these other provisions and in these other arenas. And, under the best of circumstances, would provide additional authorization and constitutional authority and symbolic authority for those efforts. I do think that there are, regardless of whether there is specific language in the Constitution protecting sex equality, we know that these provisions are not self-enforcing. And so, sort of regardless of whether the ERA is considered to be ratified or not, it's an ongoing process, I think, and an ongoing struggle to define what it is we're asking for. Excuse me. And I think we've already listed a number of different ways in which the current legally protected versions of equality can be very limited, and the way that courts have interpreted existing provisions have been limited. But I also think it's really important not to, in our efforts to sort of envision what an ERA might do, not at all to undermine what existing provisions might do and what under existing law, Congress and state legislatures and local councils are already empowered to do, and don't. While the ERA would be a wonderful supplement to what we already have, ultimately it's I think about the political will to envision and then implement these broader visions of equality.
Yeah, and I think it's a great point, because you want to take an expansive view of what the ERA might enable and authorize, and yet in the event it does not become understood to be part of the Constitution. There are a lot of tools that legislators and government actors have to do things like better protection for pregnancy and child care and employment discrimination and the range of other kinds of protections that they are certainly authorized to do. But I think that advocates are right that, again, to return to the Supreme Court's somewhat cramped vision of, say, this is a slightly different version of what we've been talking about, but Congress's authority to enforce the 14th Amendment, the ERA might more robustly authorize Congress to do things like enact paid leave, and again, more robust pregnancy discrimination and violence against women legislation, or motivated by sort of gender violence more broadly than violence against women, which is how the original the 90s statute is phrased. So all of those things I think would be within the purview of the ERA, but I think, Serena, your point is so great that acknowledging that should not be viewed as somehow conceding the lack of authority to act to advance those projects and objectives under the current Constitution, right, and statutory law. There's a CLE code that I'm gonna have to read in a moment, but I don't see it on the screen yet. So maybe I'll ask one brief question, actually. Serena, you and feel free to pop it up in the chat, please, if you guys don't mind. But I wanted to ask actually a quick question, Serena, because you said something so interesting. We hadn't talked about the sort of the moment in which there are it feels like a lot of anti-democratic forces sort of arrayed, and the connection between the sort of the precarious moment it feels like American democracy is in and this kind of gender justice movement. And I do think it's so important to think of them as not distinct phenomena. And I do wonder if there's more you wanted to say about that, and also whether I'll finish this thought and then I see the CLE code. Whether there is something, whatever happens with the ERA, to my mind, and this again, my colleague Julie Suk has made some version of this point, which is most of us, like, lawyers in our 40s or 30s, or, we haven't known constitutional amendments. The 27th Amendment in 92, it didn't really, it prevented Congress from raising its own salary. It was not a transformative constitutional moment. So the prospect of amending the Constitution is something that has not really been on the table in most of our lifetimes. And there's something incredibly important to my mind about the fact that, largely because of the leadership of and on the ground activism of women organizers, women of color in particular, in these final 3 states, but more broadly in sort of this ERA revival movement, it's a real possibility. And does that have some potential transformational impact outside of the realm of the potential inclusion of the ERA in the Constitution, and any other connections between sort of, again, the moment of sort of crisis in American democracy, if I don't think is quite too strong a description, and what we're talking about here. And Serena and anyone else, I'd love your thoughts on this, but let me first say the CLE code that I'm supposed to read here is WME 83. Oh, and the CLE code is now up on the screen, WME 83. So sorry for that interruption, but I'd love any reaction to that, and then I'll take some questions from the audience.
So here I'll be in part echoing a point that I think Julie Suk has really powerfully made, which echoes what you were just saying, Kate, that the very act of amending the Constitution, given how difficult it is, really, I think, puts on the table a lot of other pro-democracy reforms that I think we sometimes have a bit of a defeatist attitude about. So I think we often think, the Electoral College is terrible for democracy, but there's really nothing we can do about it. Or, we don't have an affirmative right to vote in the Constitution, and so we're having to try to enact legislation and overcome what's really a very concerted effort to undermine democracy in all sorts of different ways. Maybe those kinds of constitutional changes aren't as impossible as we think, if it is in fact possible to get through this Article 5 process. And I guess it struck, I think it struck a lot of people I guess it was not last year, in 2020, when we simultaneously, or almost simultaneously at least, celebrated the anniversaries of the 19th Amendment and the 15th Amendment, the degree to which the whole enterprise of women's suffrage, or of universal adult suffrage, maybe a better way to put it, is one that that really didn't happen with the 19th Amendment. It didn't happen until the Voting Rights Act, and it's really in very profound danger right now. And so I guess, as you said, Kate, the same spirit and the same, to a large degree, the same type of activism, again, by women of color, and which has a really long history that's been beautifully articulated by Martha Jones in her recent book Vanguard, has really been at the center of both of these movements, of the feminist movement and the related movement to make sure that everyone has the ability to participate in democracy. So I do think there are some really important synergies, not just kind of on the level of law, but also in the more symbolic and aspirational way that you were suggesting.
Beautifully put.
I just
Anybody else
wanted
want to
to-
jump in? Yeah, please, Alex, go ahead.
Yeah, I just wanted to jump in to just say, it's so interesting to hear this kind of discussion about the pros and cons of ratification, and whether ratification or lack thereof might sort of, by sort of legislative inaction, then imply that there is not this reach of this protection, and sort of like, do you have this kind of like, in a way, belt and suspenders kind of approach to trying to sort of like move forward on multiple grounds? Because it actually really reminds me of, the discussions around the Equality Act, right, which is still something that has not been passed by Congress, that would mandate on the statutory level federal protections for sexual orientation and gender identity. And, there was that kind of argument in the run up to Bostock of, well, if you're pushing for this in Congress, aren't you implicitly conceding that this is not a protection that you have already, right? And there was a real concern about, whether or not that would be in fact the case. But, the reality of these things is that there's no cabal that's controlling these things. And so people are going to push on multiple levels because people want things on multiple levels. And I think that the lesson I would draw from that particular effort, right, is actually that, it is not the worst. It's maybe a good thing to push on multiple fronts, because pushing on multiple fronts harnesses a degree of energy across all levels of civic society in a way that's ultimately helpful. And I do think that the only silver lining I can see about, what's about to happen with Jackson, Women's Health, and all of these cases is that I'm hopeful that perhaps this could be a galvanizing moment, right? That, this kind of discussion of the ERA can kind of be almost a little bit, theoretical and doctrinal in this way that's really not accessible to the masses, but that perhaps this is part of a movement during which this time can be used to harness that energy that people have to organize and to be in conversation with people, right? Because ultimately, I think, a lot of the gains of the LGBT movement have come on the backs of a combination of smart lawyering and strategy, but ultimately winning hearts and minds, people being willing to organize, people being willing to have these conversations with their friends and neighbors, people being willing to have these fights in, red states and southern states and across the country. And ultimately, I think there's really no substitute for that level of engagement, right? And I think that anything that harnesses that encourages that encourages people to believe that they can make change in their lifetimes that affects the fabric of this nation and the lived experience of people's lives, like that is what empowers people to participate, that belief that you can change things for the better. And I think anything that we can do now to give people that hope is so vital to preserving our democracy, as well as to protecting the marginalized people in our society.
Thank you for that. That's so well put and so important. Okay, so I'm sorry, we're not going to have time for tons of questions, but let me read one. There's an interesting one about so proposed amendments to some state constitutions, and the New York State Constitution is referenced here, would explicitly include references to gender equality, pregnancy outcomes, similar categories. So making explicit some of what the panel has suggested is very much implicit in the language of the current ERA. But the question is about concern about conflict with religious liberty, and whether, and I think that the question actually is equally applicable to an ERA that is more broadly worded and one that it more particularly enumerates other different kinds of protections. But is there a concern that religious liberty objections would be, given the extremely protective approach to religious liberty claims that this current Supreme Court takes, that some of the expansive protections of the ERA that we are imagining might actually, run into religious liberty objections that the Supreme Court would credit. So any thoughts that any of you have on that? I think it's an important question to raise.
Can I respond with a question, which is, I think it's so fascinating because actually, when you study the way that the religious exemptions fight is playing out when it comes to like LGBT issues and gender and sexuality, right? You see is that very two-tier treatment of the way that the court has historically treated it when it came to racial discrimination, and said, hey, when it comes to racial discrimination, this is like a paramount thing in our society and in our culture that we've done wrong. And therefore, if there's a paramount social interest that overrides or is, enough to defeat strict scrutiny when it comes to religious interference. I'm just wondering if you get the ERA up there on that strict scrutiny level, is it going to like really force that? Because right now I feel like the problem is that these, gender sexuality claims are always on intermediate scrutiny territory. And then it's like, oh yeah, conscious objections, no problem. But I just wonder, are we going to just does that give us a really strong reason to flip it around? So really curious to hear what people think.
I mean, yeah, I think you have just like sort of uncharted territory, right? The sort of highest constitutional protection for religious liberty and the highest constitutional protection for, against discrimination on the basis of sex and other protected, gender identity, other characteristics. I think that there are scholars who say that the court, is clearly engages in a hierarchy of rights and protection, and that religious liberty is entitled to the highest protection as against other kinds. But you're right, of course, it hasn't been willing to say that explicitly with respect to a protection against discrimination on the basis of race, but largely by pointing to the explicit protection in the 14th Amendment, right, against racial discrimination and sort of by negative implication, the lack thereof with respect to sex and related characteristics. I think it's pretty uncharted, and I don't know if others have sort of thoughts or reactions, and otherwise I can move on to another question. I mean, I do think, yeah, please go ahead, Ting Ting. Yeah.
Sorry, Kate. I was just gonna plug the other project under the Center for Gender and Sexuality Law. It's as the ERA project, but then also my wonderful colleague Liz Platt at the Law, Rights, and Religion Project, and she writes reports about this. Is the increasing sort of elevation of religious liberties that the Supreme Court has taken to elevate religious liberties above all other individual rights, and what that sort of implicates for the status of individual rights, or how courts are able to kind of resolve these conflicts that will come up in the democracy. And just to quickly touch on this question about the New York State ERA, we've actually been working on the drafting of the state ERA, and it has been, I think the question is kind of stalled at the religious liberties question, and it's a very complicated question. So I'm not able to go into it like right in this moment, but certainly, one thing that I think Serena brought up, that's the difference between something like the 14th Amendment and what would be different in the ERA is certainly that kind of intent requirement, is that the 14th Amendment requires intentional discrimination, and also won't be looking at sort of disparate impact or kind of like other sort of environmental factors of discrimination, and the ERA is not bound by that requirement. And even the 14th Amendment, that interpretation can change maybe in the future. But with the New York State ERA, it does take into it does take disparate impact into consideration. And I think there's a question there about how that kind of interfaces with the religious liberties protections under the kind of Supreme Court interpretation of that right now with the elevation. And the other question about the New York State ERA is like, so much of the federal ERA, even though it's maybe not in the Constitution, it's been doing kind of the work of advancing equality, I would say. And you could see that New York has been inspired by that, by the federal ERA, by going above and beyond, and by being inclusive and explicit about pregnancy outcomes. And the question I have is sort of like, are there any downsides to being explicit? Like, will there be requirements in the federal ERA that, well, nothing's enumerated, so it doesn't include that. So that's the only real downside. But I love that, as Alexander says, the ERA doesn't say women exclusively. It's just, in a sense, it's for everybody, and you can take a broader interpretation of the ERA. You can adopt different models, an anti-subordination model to the interpretation of the ERA. And so, New York represents that kind of expansiveness that we'd hopefully look for at the state level.
think that's a perfect note to end on. I'm sorry to those in the audience that we didn't have time to get to your questions. They're great questions, but I know that Birnbaum has a lot of other upcoming programming, maybe not on ERA in exactly the same way tonight's program was, but tons of related programs. So I think Abby might turn her camera back on and tell everyone about those. How was that? Was that an okay segue to you?
This is all perfect. Thank
Okay,
you
good.
so much to all of our incredible panelists and to Teresa for her wonderful introduction. We're so thrilled that you all joined us tonight and so grateful for you all sharing your expertise. We're also incredibly grateful to all of our attendees and to all of our co-sponsoring organizations tonight. So of course, the Ms. Foundation for Women, the ERA project at Columbia Law's Center for Gender and Sexuality Law, and NYU Law's Law Women and Outlaw. So we hope to the audience that you will join us, as Professor Shaw mentioned, to join us at our future events and sign up for mailing lists, and so follow us on your social media of choice to stay updated on all our upcoming events, including the final panel in this series with the Ms. Foundation, the Fight for Gender Justice series, the next generation of gender justice, which will be coming up in April. So stay tuned for more on that. Here's some other events coming up on your screen, and thanks again for joining us. Have a wonderful evening.